At this time, the court will call the case of State of Wisconsin versus Michael Koenig, case number 16 CF 659. Appearances for the record.
Angelina Scarpelli on behalf of the state.
Attorney Christopher Reipert on behalf of the defendant Michael Koenig, appearing by Zoom.
We are here today for the court's decision on the defendant's motion. Can you hear me? Okay. We are here today for the court's decision on the defendant's motion for a new trial based upon ineffective assistance of counsel. Now, before I announce my decision, the first thing I'd like to address with Mr. Eipert, is it correct that Mr. Koenig is agreeing not to be present for my decision today?
That is correct, Judge.
And for the record, he said yes. If you nod your head, is that correct, Mr. Eipert?
Yes, I did say yes.
Okay. And because this is a non-evidentiary hearing, the court would find it'd be appropriate for me to announce his decision without his presence, but I want to make the record that he was fine without being present. So with that, then, at this time, the court will be announcing its decision. The defendant was charged with 2 counts of sexual assault of a child under 16 years of age and 2 counts of attempted sexual assault of a child under 16 years of age. The court permitted the state to introduce other evidence as related to an incident involving an attempted sexual assault by the defendant against TNL in Iowa and a sexual assault of the defendant's sister by the defendant. The defendant was found not guilty on count 1, sexual assault of a child under 16, and count 2, attempted sexual assault of a child under 16. At counts 3 and 4, the defendant was found guilty of sexual assault of a child under 16, attempted sexual assault of a child under 16. The defendant set forth 6 things that Attorney Ralph Zagowski failed to do during the trial as to his claim of ineffective assistance of counsel. Those things are: trial counsel was ineffective for failing to object to the state's burden shifting argument during closing arguments. Trial counsel was ineffective for failing to call character witnesses regarding Michael's honesty. Trial counsel was ineffective for failing to object to the testimony of Susan Lockwood. Trial counsel was ineffective for failing to call any witnesses to the alleged Iowa incident. Trial counsel was ineffective in failing to call any witnesses regarding the timing of the Mother's Day weekend incident, count 4. And trial counsel was ineffective for failing to impeach EKK's testimony regarding the Mother's Day weekend incident. It is the defendant's position that these inactions by counsel rendered his representation of the defendant ineffective and that the defendant is entitled to a new trial. The Supreme Court, in the case of State versus Johnson, 153 Wisconsin 2nd, 121, 449 Northwest 2nd, 845, a 1990 decision, set forth what a defendant had to prove to receive a new trial due to ineffective assistance of counsel. The court held the right to counsel is the right to the effective assistance of counsel. The benchmark for judging whether counsel has acted ineffectively is stated in Strickland versus Washington, 466 U.S. 668, 1984. That requires the ultimate determination of whether counsel's conduct so undermine the proper functioning of the adversarial process that the trial cannot be relied on as having produced a just result. The overall purpose of this inquiry is to ensure that the criminal defendant receives a fair trial. A fair trial is defined as one in which evidence subject to adversarial testing is presented to an impartial tribunal for resolution of issues defined in advance of the proceeding. The Strickland Court set forth a two-part test for determining whether counsel's actions constitute ineffective assistance of counsel. The first test requires the defendant to show that his counsel's performance was deficient. This requires showing that counsel made errors so serious that counsel was not functioning as the counsel guaranteed the defendant by the Sixth Amendment. Review of counsel's performance gives great deference to the attorney, and every effort is made to avoid determinations of ineffectiveness based upon hindsight. Rather, the case is reviewed from counsel's perspective at the time of trial, and the burden is placed on the defendant to overcome a strong presumption that counsel acted reasonably within professional norms. Even if deficient performance is found, judgment will not be reversed unless the defendant proves the deficiency prejudiced his defense. This requires showing that counsel's errors were so serious as to deprive the defendant of a fair trial, a trial whose result is reliable. The court further held, when reviewing a claim of ineffective assistance of counsel, the Strickland Court states that courts may reverse the order of the two tests or avoid the deficient performance analysis altogether if the defendant has failed to show prejudice. Although we have discussed the performance component of an ineffective assistance of counsel prior to the prejudice component, there is no reason for a court deciding an ineffective assistance of counsel claim to approach the inquiry in the same order or even to address both components of the inquiry if the defendant makes an inefficient showing on one. In particular, a court need not determine whether counsel's performance was deficient before examining the prejudice suffered by the defendant as a result of the alleged deficiencies. The object of an ineffectiveness claim is not to grade counsel's performance. If it is easier to dispose of an ineffective assistance counsel claim on the ground of lack of sufficient prejudice, which we expect will often be so, that course should be followed. Courts should strive to ensure that ineffectiveness claims not become so burdensome to the defense that the entire criminal justice system suffers as a result. The court further held, the Strickland Court places the burden on the defendant to affirmatively prove prejudice. Even if a defendant shows that particular errors of counsel were unreasonable, therefore, the defendant must show that they actually had an adverse effect on the defense. The court further instructs that not every error that conceivably could have influenced the outcome determines the reliability of the result of the proceeding. The prejudice standard set by the Strickland Court does not require the defendant to show that counsel's deficient conduct was outcome determinative of his case. Rather, the court states that the defendant must show that there is a reasonable probability that but for counsel's unprofessional errors, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine confidence in the outcome. In application of this principle, reviewing courts are instructed to consider the totality of the evidence before the trier of fact. In State v. Hunt, 360 Wisconsin 2nd 576, 851 Northwest 2nd 434, a 2014 decision, the Supreme Court set forth standards a court should examine in determining if defense counsel is ineffective. The court held a strategic trial decision rationally based on the facts and the law will not support a claim of ineffective assistance of counsel. We will not second guess the trial counsel's considered selection of trial tactics or the exercise of a professional judgment in the face of alternatives that have been weighed by trial counsel. Comes from the Hunt decision at page 611. One of the reasons the defense states he's entitled to a new trial is because Attorney Zagalski did not object to comment made by Assistant District Attorney Jill Vendetti made during her closing argument. During her rebuttal closing argument, ADA Vendetti stated about Taylor, Mr. Zagalski made you a list of 24 things, but we haven't really talked about the defendant's list. And we know he lied in this case. Mr. Zagalski, objection, Your Honor. The court will permit argument. You may continue. Ms. Vendetti, what does it matter when someone offers to do this? He sat right here and said, I was never in her room that night. And both Taylor saw him and the other daughter, Emily, saw him. Sat here and said, I saw him in the room that night. Why would they make that up? If he was in the room that night, why wouldn't he just say he is? Because it's Mother's Day 2014, and the problem is already out there. She's been accusing him of this already. So when Nikki gets home, finds out he's been in the room that night, maybe some of the stuff in the past starts making sense. He cannot commit to being in that room that night. In order for all this to hold, I was not in the room that night, the Christmas tree, even though he had another witness that sees him trying to drag her out. And there's no evidence to contradict that. And so we sat here and we listened to this list, and we all see these distractions. And in fact, most of these were addressed. And I'm not going to take the time to go through them one by one. I'm going to put this over here. This whole point in distracting and focusing on the fact that a high school student switched a school, or after something was reported, after it's already out, at some point later on in the future, got a restraining order, that future action should somehow go back to something she's fabricated years ago. Distractions, distractions, distractions. So why do we do distractions? Because we don't want you to pay attention to certain things. It's out of design. When you have nothing, when you're lying, you point the direction somewhere else. And you believe she's the kid that would be jealous of her sister because she has to do less chores, so she's going to make this up. You hope you would believe that she is that rotten of a person, except none of the testimony you heard establishes her as that person. The only person saying it is the defendant. His quote was, "You can see the jealousy in her eyes." That's what he said. You can see the jealousy in her eyes, except her sister was there and said she couldn't. No one could see it. In State versus Bell, 380, Wisconsin 2nd, 616, 909 Northwest 2nd, 750, a 2018 decision, the Supreme Court set forth when prosecutorial comments made during a jury trial violate a defendant's due process rights. The court held, we begin with the fundamental tenet that Mr. Bell is guaranteed the right to due process of law. This guarantee extends to the state's comments during the trial. When a defendant alleges that a prosecutor's statements and arguments constituted misconduct, the test applied is whether the statements so infected the trial with unfairness as to make the resulting conviction a denial of due process. These due process considerations do not, however, prevent the state from energetically pressing its case. The state's attorney is free to prosecute with earnestness and vigor. Indeed, he should do so. But in conducting a trial, he must keep in mind that he represents a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. For that reason, while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods, calculation to produce a wrongful conviction, as it is to use every legitimate means to bring about a just one. The court further held, we cannot, of course, look at the state's comments in isolation. We must examine them in the context of the entirety of the trial, including the nature of the defense Mr. Bell presented. It is fair to say and evaluate Mr. Bell's claim, context is everything. The defense here points to a single clause in Ms. Vendetti's argument where she stated, quote, "when you have nothing," end quote, as the basis that she shifted the burden of proof in this case. In determining whether Mr. Koenig's due process rights were violated by this comment, the court needs to examine the statement in the context of the whole trial and not in isolation. When you look at the partial comment in its context, in just the rebuttal argument alone, it is clear that when she made the comment that she was referring to Mr. Zagalski's list and his closing argument as it related to that list. Furthermore, in her rebuttal argument, she references the beyond a reasonable doubt jury instruction. This instruction clearly states that the burden of proof is with the state. This clearly shows that Ms. Vendetti was not burden shifting as alleged by the defense. Lastly, the defense cites no other instance during the jury trial where they claim she was acting inappropriately during the trial. Therefore, the court finds that Ms. Vendetti's actions did not violate the defendant's due process rights in her closing argument. Because of this, Mr. Zagalski was not ineffective in failing to object to this comment made by Ms. Vendetti. The defendant takes the position that Attorney Zagalski was ineffective because he failed to call witnesses as to the defendant's character for truthfulness under Wisconsin Statute Section 90608. There were a number of witnesses that the defense claims would have testified at the trial that the defendant was a truthful person. These witnesses included family members, friends, and co-workers. The defense called 8 witnesses to show during the Mockner hearing who would have testified that the defendant was an honest person. The defense asserts that Attorney Zagalski was ineffective by not calling his witnesses because credibility of the defendant versus the victim was important in defending the case. Attorney Zagalski testified during the hearing about why he did not call character witnesses on the defendant's behalf. The court this time is going to be referencing to part of the testimony from the March 13th, 2020 hearing. First, as to page 54, it states, question, you didn't call any witnesses to testify as character witnesses with respect to its character for being a truthful and honest person, correct? Answer, of course not. Question, was that something that you considered? Answer, I thought about it, but I knew that would be a rookie mistake to do that, given the fact that other acts were going to be allowed to get into by the court. Question, was there discussion between you, Mike, Nikki, Jason, Janet, or any others that were assisting, like in his defense about calling character witnesses? Answer, once the other acts motion came in regarding the sister, I knew that bringing in other family members would likely be a very bad idea. Because here's the thing, nobody felt, I don't think, sitting in the jury that Mike was a bad guy. He presented himself beautifully on the witness stand. Every single juror I talked to after the trial had a very good view of him. Question, so let's take, you brought up family members. You thought it would be a bad idea to bring family members in as character witnesses. There's a huge downside to that. Question, now we're on page 55. What were you concerned about on cross-examination of Jason Koenig that would have been harmful to the case? His partial answer, as far as bringing up the fact, oh yeah, he's a great guy. I mean, Jill Vendetti, even if she wasn't allowed to ask questions, could certainly have argued, yeah, his own brother, the police officer, comes up here and says what a wonderful guy he is. What He's ignoring the fact that he was convicted of molesting his own sister. That would have been a devastating and closing argument. Next, it also says on page 56, as part of an answer, sure, but I know Miss Vendetti, and she could have put forth a very good and convincing argument that could have turned that into basically his own brother ignores the fact that their mutual sister was molested by him years earlier. Page 57. Question, why do you think the DA would have been able to ask Jason Koenig about that? What does it have to do with his character for honesty and truthfulness? Answer, he's a witness. He would have been called. It would have been pretty much an open door for the prosecution to ask whatever questions she wanted. Now, even if I object and the question is sustained, the jury still heard the question. And believe me, the trial went about as well as it could have up to the point that Mike testified. The jury was, I think, emotionally on our side, and in my discussions with them, they were. Turning to page 93. Question. You had testified before that you felt that bringing in character witnesses was a rookie mistake. Is that correct? Answer. In a case like this with other acts being allowed in, I believe so. Question. In your past 60-some trials that you have done, have you seen where a character witness only comes into talk about this person as honest or truthful does, and not talking about dishonest? I think there's a difference there. But someone coming in saying this person is honest and truthful, do you think that has an impact on the case? Answer, the problem is I've known very few people who I've considered things. There's a good side and a bad side to everybody. And if I bring in a witness who thinks a person is utterly and truthfully honest, here's how it can play out in court. For example, sarcastically, a prosecutor could say, are you saying this person never, ever lies in their entire life? Well, no, I can't say that. And then you can go down the road of, if they get in trouble, yes, will they lie? And then it just becomes a mess. And I don't think it really goes anywhere. And I think it puts a bad idea in the jurors' head about, this person does have a little bit of a dark side. Continuing in part. And I didn't need anybody to perhaps question that by saying, yes, he's honest, he's wonderful, he's great. I guess everybody can lie from time to time. Oh, that would be good. Wisconsin statute section 90608 states in part, 1, opinion and reputation evidence of character, except as provided in Wisconsin statute section 972.11 sub 2. The credibility of a witness may be attacked or supported by evidence in the form of reputation or opinion, but subject to the following limitations. Sub A, the evidence may refer only to character for truthfulness or untruthfulness. B, except with respect to an accused who testifies in his or her own behalf, evidence of truthful character is admissible only after the character of the witness for truthfulness has been attacked by opinion or reputation evidence or otherwise. Sub 2, specific instances of conduct. Specific instances of the conduct of a witness for the purpose of attacking or supporting the witness's character for truthfulness, other than a conviction of a crime or an adjudication of delinquency, as provided in 90609, may not be proved by extrinsic evidence. They may, however, subject to Wisconsin statute section 972.11 sub 2, if probative of truthfulness or untruthfulness and not remote in time, be inquired on cross-examination of the witness or on cross-examination of a witness who testifies to his or her character for truthfulness or untruthfulness. In State versus Collier, Cuyler, 110 Wisconsin 2nd 133, a 1983 decision, The Supreme Court discussed character evidence under Wisconsin statute section 90608 sub 1. The court held opinion evidence is not geographically limited and does not require a foundation that the witness giving the opinion testimony is familiar with the community of the person about whom he or she is testifying. Section 90608 sub 1 imposes no requirement that the witness giving the opinion testimony have a long acquaintance with the person or have recent information, since cross-examination can expose the witness's lack of familiarity with the person about whom he is testifying. Like other evidence, however, opinion evidence is not automatically admissible. The trial court may, for example, preclude a witness from giving opinion evidence as to truthfulness or untruthfulness if the witness lacks personal knowledge or if the probative value of the opinion evidence is substantially outweighed by considerations of unfair prejudice, confusion of issues or undue delay, etc. Attorney Zagalski indicated he did not call character witnesses because of what might come out in cross-examination of the character witnesses. That being, someone would testify Mike lied in the past and would lie to get out of trouble. He was also concerned if testimony came out that the defendant had lied in the past, that this would negatively affect the testimony of the defendant as to its truthfulness. In addition, he was concerned that if he called family character witnesses, it may affect his case negatively on what ADA Vendetti would say in closing arguments about these witnesses regarding the prior sexual assault committed by the defendant. The court would find that the strategy to be reasonable based in fact and law. Therefore, Attorney Zagalski is not ineffective in not calling character witnesses on behalf of the defendant. Next, Attorney Zagalski also indicated that he did not call character witnesses because of concerns about inquiry into the defendant's past would come out on cross-examination. This appears to be a legitimate potential concern because how well a person knows another person is ripe for cross-examination. There is nothing in 90608 that would preclude the state from asking on cross-examination about his prior sexual assaults once that witness testified about the defendant being a truthful person. The Kyler case appears to support this conclusion. The rule of evidence that may preclude this testimony, though, is the second prong of relevance, that this cross-examination would not be permitted because the testimony would be more prejudicial than probative. Nonetheless, this would be another proper basis for Attorney Zagalski to not call these witnesses. In conclusion, as to this issue, the court finds Attorney Zagalski was not ineffective in calling character witnesses. The defense takes the position that Attorney Zagalski was ineffective in representing the defendant because he failed to object timely as to the testimony of Susan Lockwood. The state filed a notice of intent to introduce expert testimony on September 7, 2017. It has the old case number on it as it relates to this case. It states, the state having previously filed a notice of intent regarding this expert witness testimony and having disclosed this witness on the state's witness list and the state's amended witness list again, pursuant to Wisconsin statute section 971-23 1C and 907-02 with that, the state is providing notice that it intends to introduce the expert testimony of Susan Lockwood, psychotherapist and director of the Sexual Assault Resource Center and Willow Tree Cornerstone Child Advocacy Center in Green Bay, Wisconsin. Ms. Lockwood's curriculum vitae was previously turned over to the defense counsel. Ms. Lockwood's testimony is intended to assist the jury in understanding evidence relating to sexual assault victims, including grooming, delayed reporting, child victims, behavior during an assault, and post-assault behavior. This testimony is permissible under State versus Jensen, 147 Wisconsin 2nd, 432 Northwest 2nd, 913, 1988. In Jensen, the court held that the courts may allow an expert witness to give an opinion about the consistency of a complainant's behavior with the behavior of victims of the same type of crime, if testimony will assist the trier of fact to understand the evidence. The court explained that this type of testimony is relevant both to rebut a defense claim that the charge is fabricated, and because the victim's behavior frequently does not conform to commonly held beliefs of how a victim would react. The reference that the state previously filed a notice comes from the previous case as related to the charges in this case, a Manitowoc County case number 15 CF 509. And that one states, pursuant to Wisconsin statute section 971-23-1C and 907-02 with stats, the state is providing notice that it intends to introduce the expert testimony of Susan Lockwood, psychotherapist and director of the Sexual Assault Resource Center in Willow Tree Cornerstone Child Advocacy Center in Green Bay, Wisconsin. Ms. Lockwood's curriculum vitae is attached. Ms. Lockwood's testimony is intended to assist the jury in understanding evidence relating to sexual assault victims, including delayed reporting, child victims' behavior during an assault, and post-assault behavior. The testimony is permissible under State v. Jansen, and it gives the site. In Jansen, the court held the courts may allow an expert witness to give an opinion about the consistency of a complainant's behavior with the behavior of victims of the same type of crime if the testimony will assist the trier of fact to understand the evidence. The court explained that this type of testimony is relevant both to rebut a defense claim that the charge is fabricated and because the victim's behavior frequently does not conform to commonly held beliefs of how a victim would act. The state also attached her CV to the notice in the previous case. The defense was aware of the previous notice. The defense filed a motion to exclude the testimony of Ms. Lockwood, claiming that no notice was filed and that the state did not submit any reports that were prepared by Ms. Lockwood in this case. Ms. Lockwood did not prepare a report in this case, and the court denied the defendant's motion. The defense infers that Attorney Zagalski was ineffective because he did not request a Daubert hearing as to Ms. Lockwood's testimony, and that the notice of intent to introduce expert testimony is deficient under Wisconsin's Daubert standard. Wisconsin statute section 90702 sub 1 states if scientific, technical, or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. If the testimony is based upon sufficient facts or data, the testimony is the product of reliable principles and methods, and the witness has applied the principles and methods reliably to the facts of the case. Under the statute, the circuit court serves as a gatekeeper so as to ensure that expert's opinion is based on a reliable foundation and is relevant to material issues. That comes from Chitwood, CHITWOOD, 369 Wisconsin 2nd, 132, paragraph 29. The court is to focus on the principles and methodology the expert relies on, not the conclusion generated, to ensure that those principles and methods have reliable foundation in the expert's discipline. comes from State versus Smith, 366 Wisconsin 2nd, 613, a 2015 decision. The goal is to prevent the jury from hearing conjecture dressed up in the guise of expert opinion. Chitwood, 369 Wisconsin 2nd, 32, paragraph 29. Considering the broad range of cases in which expert evidence arises, courts have not been constrained by the listed factors. How courts apply these factors necessarily varies case by case, expert by expert. Too much depends upon the particular circumstances of the case at issue to impose hard and fast rules. A trial court conducts its reliability analysis with wide latitude. Kumho, K-U-M-H-O, Tire, emphasized that the application of the Daubert factors is a flexible inquiry. The law grants a district court the same broad latitude when it decides how to determine the reliability as it enjoys in respect to its ultimate reliability determination. This comes from Seifert versus Balnick, B-A-L-N-I-C-K, 372 Wisconsin 2nd, 525, 557 to 558, a 2017 decision. The court in Jensen, in State versus Jensen, 147 Wisconsin 2nd, 240, a 1988 decision, examined what an expert could testify about in child sexual assault cases. The court held because a complainant's behavior frequently may not conform to commonly held expectations of how a victim reacts to a sexual assault, courts admit expert opinion testimony to help juries avoid making decisions based on misconceptions of victim behavior. In this case, Mr. Bossman's testimony was relevant because it provided information about behavioral characteristics of child sex abuse victims that may have been outside the juror's common experience. Mr. Bossman's testimony was relevant to counter the defense's explanation of the complainant's behavior and to provide the jury with an alternative explanation. Jensen at 252. The court further held, we conclude that the circuit court may allow an expert witness to give an opinion about the consistency of a complainant's behavior with the behavior of victims of the same type of crimes if the testimony will assist the trier of fact to understand the evidence or to determine a fact and issue. Section 90702 Stats 1985-86 authorizes the testimony of experts in the form of opinion or otherwise if scientific or technical or other specialized knowledge will assist the trier of fact to understand the evidence or to determine a fact and issue. While an expert's description of the behavior of victims of a crime may assist the jury to understand the evidence in the case or to determine a fact and issue, an expert may be no more qualified to compare behavior patterns than the jury. The jury may be able to draw the requisite inferences itself without the assistance of an expert. As the Federal Advisory Committee explained, in adopting the federal counterpart to 90702, it seems wise to recognize that opinions are not indispensable and to encourage the use of expert testimony in non-opinion form when counsel believes the trier can itself draw the requisite inference. Moreover, when an expert witness testimony includes the ultimate comparison, there's a risk that the jury could interpret the testimony as an opinion that the complainant is being truthful about the assault or that the assault occurred. In sum, the expert witness must not be allowed to convey to the jury his or her own beliefs as to the veracity of the complainant with respect to the assault. It comes from Jensen at 256 to 257. The court will first find that the state's notice to introduce testimony of Ms. Lockwood was proper. Next, the court would find that an expert under Jensen, if the expert meets the Wisconsin Daubert standard, can render an opinion of delayed reporting by alleged child sexual assault victims. Also, the court would find that based on the court's review of the testimony of Ms. Lockwood about her extensive experience in dealing with sexual assaults, her training and experience, and the fact that she's been qualified as an expert on 30 to 35 occasions, would find that she meets the Wisconsin Daubert standard to give testimony in regard to delayed reporting in sexual assault cases. Ms. Lockwood's extensive CV also supports this position. Therefore, the court would not find that Attorney Zagalski was ineffective in failing to request a Daubert hearing. Next, the defense states that when Ms. Lockwood testified about false reporting is not common, and that a relevant research study concluded that only 2 to 8% of sexual assault allegations are false. It went beyond what Ms. Lockwood was permitted to testify. An expert is not limited to the scope of the testimony in a notice if an attorney on cross-examination opens the door about another subject not contained in the notice. Once this door is open, the other party has the right to introduce testimony about that subject. This is exactly what occurred in this case. Mr. Zagalski elicited from Ms. Lockwood that the children's reports of sexual assault are not always truthful. This would properly open the door to the testimony of the percentage of child sexual assault allegations are false. The court would further find that Attorney Zagalski was not deficient is based upon him looking into the history of Ms. Lockwood and developing a strategy on cross-examination. He stated during the Mockner hearing, when I first saw this motion, I started asking around. I called several lawyers, as I recall, up in Green Bay. I don't recall specifically who. I believe I called the public defender's office, and I think I spoke to Chris Freilich, who is a very good defense lawyer up there, but I can't say that for sure. What I was basically told is this. She comes off as a biased crackpot, doesn't know what she's doing. It'll probably help you to have her on the witness stand. Just do a good cross-examination. And I think that's what I did. At page 47, it states, but I did talk to other lawyers who had used or had encountered her in cases. As I recall, I even talked to a prosecutor who kind of rolled his eyes when I mentioned it to him. At page 49, as I recall, there were some numbers that were bandied about and thrown around. As I recall, the best numbers were that she actually never, except maybe 2 or 3 times, actually talked, for example, someone who's been accused of sexual assault. She dealt exclusively with victims. As I recall, she did almost nothing regarding men. It was always pretty much women. Those types of things where I tried to get numbers out of her, which of course she seemed to try and evade. I thought it was pretty comical in the way that she did it. And I could see the jury, and ultimately the jury really discounted her testimony completely. The defense does not state that the strategy was not effective during trial. In conclusion, the court would find that Attorney Zagalski was not ineffective as it relates to the testimony of Ms. Lockwood. The defense also claims that Attorney Zagalski was ineffective in not calling witnesses to discredit T&L's testimony that the defendant attempted to touch her inappropriately in Des Moines, Iowa. The court permitted the state to introduce testimony that the defendant inappropriately attempted to touch T&L in Iowa as other acts evidence. The defense produced 2 witnesses that could have testified in an attempt to discredit T&L's testimony. Nicole Koenig, the defendant's wife, who was laying next to the defendant, would have said that she did not hear her husband say anything inappropriate to T&L and woke up when T&L coughed. She would have testified that TNL was in the bathroom for a short period of time and not a lengthy period of time, as TNL testified. She also would have testified that TNL, after leaving the bathroom, went back to sleep on the floor next to the defendant. Ryan Trullier would have testified that he did not hear the defendant make any inappropriate comments to TNL that night, and they woke up when TNL coughed. Attorney Zagalski testified about why he did not call a witness about the Iowa incident during the hearing. He stated in part, question, did you ultimately investigate the Iowa incident in making a decision whether to call witnesses? Answer, we did. I spoke a great deal with Mike and his wife, Nikki, as well as other family members, including Jason, and once in a while, his wife. Page 13 of 116 of one of the transcripts. Page 14, and ultimately we decided what to do with the other acts was to try to ignore them as much as possible, and hopefully the jury would not dwell on them. So we decided not to call Iowa witnesses. Question, okay, do you remember talking to Nikki with respect to the Iowa incident? I'm sure, yes. Question, okay. Answer, and I think Mike was always there when I did. Page 15. Question, do you recall talking to any witness that could have discredited that testimony of her actually sleeping in the bathroom? Answer, I don't think there was any real controversy that at some point in the morning, as people started to stir, that she was indeed in the bathroom. I had a good grasp of what I'm sure, but I really just tried to stay away from that incident. Fine, it was introduced on the first day of trial. Let's not have it talked about anymore. And thankfully, we were successful. It really was not dwelled upon by the prosecution or myself. Page 18. Answer, well, I remember speaking to Mike and Nikki about that quite a bit. But on balance, a strategic decision was made to stay away from Iowa as much as possible. If we want, I can talk about the jurors I talked to after the trial who said at the Iowa incident, they hardly even seemed to remember it. Not that that was excellent. We actually handled that perfectly because it was mentioned on the first day and essentially forgotten. If we had brought in witnesses of this nature, it might have been the foremost in their minds and probably would have hurt us. The court would find this to be a reasonable trial tactic within professional norms. Furthermore, this tactic was thoroughly discussed with and agreed to by the defendant. This would also be a factor that shows that Attorney Zagalski was not ineffective in utilizing this trial tactic. Also, in reviewing the testimony, there were potential issues in calling Nicole Koenig and Ryan Trullier. The court will first address Ryan Trullier. He testified that he was asleep up to the point that TNL coughed and that he assumed it was TNL that coughed. He also indicated that his memory was kind of fuzzy about the incident. Next to Mrs. Koenig, there was a lot going on during the trial. It was decided not until the last day that she would testify. This was based upon discussions she had with Attorney Zagalski. She had testimony that was helpful to the defense, but she also had testimony that was problematic from the court's perspective, based upon the cross-examination that occurred during the hearing. She testified that TNL after the Iowa incident, but prior going back to Iowa again, that TNL had told her that the defendant had done stuff to her in Iowa in the previous year. The court this time will quote from some of the other excerpts of her testimony that it would have been problematic for the defense. Again, I'm referencing the Mockner hearing. And this is page 64 of 90 of one of the transcripts. So when was the very first time that Taylor had told you that Mike had touched her inappropriately? It was run the last days of school in 2013, page 65. All right, so my question was, Taylor had told you there had been inappropriate touching. Did she specifically tell you? I mean, was it kissing or was it sexually touching? What was inappropriate? She said that he had touched her back and went to her stomach and went to like her under her bra. Continuing on 65, how did you react to this discussion? Answer, I was upset that could have happened in my house. Question, did you take any sort of precautions to try and protect Taylor? Answer, yes. Now we're on page 66. Yes, we had stayed away for 2.5 weeks in a hotel. And then the next, I would say 2. It was, I think, 2 more weeks that she had stayed by her dad, and then she wanted to come home. Page 67. Were there times after that Taylor ever told you that her dad was touching her inappropriately? Question, or that Mike was touching her inappropriately? Answer, correct. Yeah, it was the following year. Page 68. This is an answer. In 2014, we went in 2015, she told me. So it was little tidbits of her telling me through the years that was the inappropriate touching. Questions, how many times do you think there were these little tidbits? Answer, 3. Question, and you talked about moving out of the house and her going to stay at her dad's. Was there anything else that you had done to try to protect Taylor? Answer, yes, she was not alone with him whatsoever. I was either with, or she wasn't alone. Question, again, page 68. Okay, so was there ever a time that you put a lock on her bedroom door? Yes, when was that? After the Christmas tree incident that Mother's Day. And after the Christmas tree incident, had you discussed that with coworkers of yours? Answer, yes. What did you tell your coworkers? Answer, I just said how it happened, how she described it, and what my thoughts and feelings were about it. And question, and what were your thoughts and feelings about it? Answer, I didn't believe it. I don't know how it could have happened in such a short amount of time. Question, so why were you discussing this with your coworkers if you didn't believe it happened? Answer, for somebody to help me try and figure it out. Question, and how did your coworkers respond? They just listened. Question, did they tell you that you should believe Taylor? Question, I had asked you how your coworkers had responded, and you indicated that they had just listened. Is that correct? Answer, yes. And I had asked you, did they tell you that you should support Taylor or believe Taylor? Answer, it was kind of hit and miss. They were telling me if it was their child, that they probably would believe the child. But it was such a small window that they didn't know what that would think. Page 71. Question, and did you tell Detective Jacobs that your coworkers said that you should believe Taylor? At one point, yes. So at one point, you moved out of the house, you tried to make it so Taylor was not alone, and you put a lock on her door. Is that correct? Answer, yes. The court would find that not having the jury hear this testimony would support a conclusion that Attorney Zagalski was not ineffective in calling these 2 witnesses about the Iowa incident. The next claim of ineffective assistance counsel relates to an incident that occurred around Mother's Day. This became known as the Christmas tree incident. The defense claims that Attorney Zagalski was ineffective during the trial because he failed to call witnesses to show that there was a short period of time in which the defendant could have attempted to sexually assault TNL. and to discredit T&L's testimony that the incident occurred 1 to 2 hours before her mother got home from work. The defense had a number of witnesses that would have testified that the defendant left a bonfire with others shortly before 2 a.m. There were witnesses that would have specifically testified that they drove the defendant home after the bonfire at 2 a.m. All these individuals were drinking that evening. Nicole Koenig would have testified that she got home shortly after 2 a.m. The court agrees that this testimony would have been helpful to show that if the jury believed this testimony, that there was only a short period of time in which the defendant could have attempted to sexually assault T&L. This testimony, though, would show that he also, though, would have had the opportunity to attempt to commit the assault. Furthermore, had Nicole testified, she'd be subject to cross-examination, which would lead to an introduction of evidence, as the court has previously stated, which would not be favorable to the defendant. In light of all this, the court finds that not calling these witnesses regarding the timeline would not be so prejudicial that the result of the proceeding would have been different under the second prong of the Strickland test. The defense next claims that defense counsel is ineffective because he failed to impeach EKK during the trial through cross-examination or through the testimony of Detective Jacobs. During the trial, EKK said that she saw the defendant in the room the night when the Christmas tree was knocked over. We're impressed further by Attorney Zagalski about this. She continued to stand behind this position. When doing this, Attorney Zagalski referenced a taped interview that occurred between EKK and Detective Jacobs and Detective Bessler on April 24th, 2014. During that interview, EKK stated during the interview, quote, "I thought it was weird. I couldn't say why he would come in the room in the middle of the night," end quote. She did not say during the interview that the defendant was in the room. She also did not say that he was not in the room. This would not be a prior inconsistent statement. In addition, she said during that interview that she saw or heard the tree crashing and saw broken bulbs. She also said T&L told her that her father was in the room and asked if they could switch places in case the defendant came in the room again. This information would corroborate some of the testimony of this witness and T&L. EKK was interviewed again on April 28, 2015. During the course of the interview, she does not specifically say one way or the other if the defendant was in the room. However, when Detective Jacobs stated the defendant was in the room the night of the Christmas tree incident, she says, She does not say in response to Detective Jacobs that she did not see him in the room. During that interview, she makes statements that corroborate what happened that night. When upon reflection, she says during the interview that she should not have ignored what was going on. She then on her own describes more about the incident. She talked about fighting back, trying to get away, and jumping all over. And that was by T&L. This information would be consistent with the testimony that came out during the trial from EKK and T&L. The court would find that Attorney Zagalski's decision to not impeach EKK through the tape would affect the outcome of the trial as required by the second prong of the Strickland analysis. The defense also indicates that Attorney Zagalski was ineffective in not calling Mrs. Koenig as a witness. Nikki testified during the Mockner hearing that she was told by EKK that she did not see the defendant in the room on the night of the Christmas tree incident. The court has previously found that it was appropriate trial tactic not to call her as a witness. The same reasoning would apply to calling her to impeach EKK. In addition, the state did not have EKK excused as a witness for the trial after she was called during the state's case in chief. Had Nikki testified, the court presumes that based upon the second interview, the state would have recalled EKK to testify in rebuttal. During the course of that second interview, EKK talked about Mrs. Koenig's behaviors while this case was pending. The jury may not have viewed these behaviors as appropriate. So as to the Christmas tree incident, there were things Nikki could have testified about as to the credibility of, about, strike that. So as to the Christmas tree incident, there were things Nikki could have testified about as to the credibility of, about EKK, while at the same time, there are things that could have come out about Nikki's behavior. The court would find this to be an appropriate reason not to call her as a witness to impeach EKK. As to this issue, the court would find that Attorney Zagalski was not ineffective as it relates to this issue. Lastly, the court would find that even taking all these issues as a whole would not find that Attorney Zagalski's performance during the trial to be ineffective. So I will respectfully deny the motion. Ms. Scarpelli, you'll be drafting the order. Madam Clerk, before I close the proceeding, is there anything else I need to address? Anything further from the attorney? So I'll start with Ms. Scarpelli.
Nothing further, Your Honor.
And anything further from Mr. Eipert?
No, Judge. Thank you.
All right. With that, we are adjourned. Thank you.